All right. Good afternoon, good evening, ladies and gentlemen, from wherever you are joining us. And thank you and welcome to Afrique 24-hour TV. Of course, I'm glad that you're watching Afrique 24-hour. This is a talk show that comes to you on a daily basis, a talk show that connects you with African stories, a talk show that connects you with Africans from across the world. Of course, today is a very good afternoon here. It's a nice Friday, despite what is happening within the country. I know the country have been experiencing some protest by the younger generation who are protesting against the Finance Bill 2024. And of course, today we are not discussing that. I'm having a guest with me here. I'm having Kennedy Abuya, who is a lawyer. Of course, he's joining me all the way from another country in East Africa. I'll give him an opportunity to tell you that for those people who've been watching this platform, of course, one of these days or maybe previous days, we've been able to interact with him. So thank you so much, Kennedy, for and coming to Afrique so that we can have these candid talks on the role of regional courts in Africa's integration agenda. And I do appreciate and take this time to welcome you to Afrique so that you can be able to say hi to our viewers and maybe give them a brief introduction of who Kennedy Abuya is. Karibu sana.
Hello, thank you so much. Maybe let me check if you can hear me well from wherever you are. Hello.
You just proceed.
All right. So my name is Kennedy. Of course, it's there shown on the screen. I'm a lawyer and a regional consultant on matters of regional economic operations, integrations, and among others. And it's not my first time appearing on this platform. So I think your fans or followers probably we shared a lot those the previous time that of course I appeared and we were discussing other topics. Basically, I would just say today again we shall be going deeply to understand the role of these regional judicial bodies and how do they relate to our national what called municipal judicial bodies like national courts, and how are they important to you and me or to any other person, whether in business or as a private person or even generally as a country or as a state that belongs to some of these regional arrangements. So I think more is going to come as we discuss. Thank you.
Sorry, I don't know what has happened from my end, but you can proceed, Kennedy.
Actually, my introduction is done because we lost you. I actually lost you, so I think I've done the introductory part, so we can proceed.
Thank you so much for introducing yourself and welcome to Afrique. Of course, today, as our viewers can see, we are going to specifically look at the role of the regional courts in Africa's integration agenda. And maybe to start us off, I would just want to get to know what are some of the regional courts that we have specifically within Eastern Africa, maybe before we go to Africa. because most citizens or most of the viewers, when they talk of courts, they only know of the jurisdictions that we're having within the country, and they'll tell you they know of Supreme Court, which is the apex court in the country. And some of these things came to be known after the 2022 general elections that was disputed. After the court upheld the win of the president, we had one of the Azimio, the deputy president, the deputy or the running mate, Raila Odinga, saying that she was going to East African Court of Justice. So Kenyans were like, do we have some other courts outside the jurisdictions of the ones that we know within Kenya? So maybe you can just give us some brief of these regional courts and maybe their mandates.
Yes. So basically, I would wish maybe to so that we need to start from your first statement, as in we cannot have this discussion if we just concentrate on East Africa. We need to follow it from Africa because when you talk about regional courts, there are different
I
levels
get
in which
you.
we can solve regional courts. So within EAC or within East Africa community, we only have one regional court. So then we cannot give an example with one. So for the benefit of the viewers and those who want to understand it, we must begin this conversation by understanding the regional judicial architecture within the African continent. And basically, uh, within the at the African level, we have what we may also call a regional court because it's a continent-wide court. And we have two types of
Mhm.
courts there. And we have the African Court of Justice, and then we have African Court of Human and People's Rights. But the viewers, probably those who would want to know more, is that these two courts actually were joined together, and so that they would, ease pressure in terms of resources and in terms of, their management. So that is something that happened very recently. So now that is a regional court at the level of the continent, and its purpose basically is to, for example, the African Court of Justice. Its purpose is to help, solve disputes between or amongst, African member states. And then now, within that, we can also say, apart from at the continent wise, we also have regions. So the genesis of regions in Africa, we trace it in 1991 in what we call the Abuja Treaty on the African Economic Community. And basically what it established is they wanted, Africans to form groups, and then from these groups they will be able to integrate and then eventually become, probably United States of Africa. And those discussions, I think so many commentators have, have explained, the likes of Professor Pielo Lumumba has explained this by mentioning those discussions that were held between Nyerere and Kwame Nkrumah. Kwame wanted us to abandon all the territories immediately, and on the other hand, Nyerere was like, no, we cannot do it immediate. Other people are still struggling. Actually, at that point, there were not all African states had already received, or rather gotten their sovereignty, back from the colonial powers. So now, so they opted in 1991. They formalized and they say, okay, let us now group Africa into different regions, and that is how we came up with different regions like ECOWAS, EAC, like ECAS, like SADC, now being recognized within African-wide agenda. So why do I say being recognized as such? Because regional corporations like the EAC and whatever, actually they are older than that age. They are older than that age. So it was 1991 that now it was put into a treaty so that they would be given timelines within which they are supposed to do certain things and merge, and form, a one Africa, whatever territory as our, those great men like Kwame Nkrumah, great men and women, Kwame Nkrumah, Nyerere, and so forth, had said. So let us come to the court. So for these regionals or regionalizations to function. Already we had others like the East African Cooperation. By that time it was called East African Cooperation. Already we had the East African Court of we had the East African Court of Appeal. That's what we had actually during those particular time. Are we together? Leon, I'm not getting you.
You. So the East African Cooperation. So this one is the one that we had, the one that was formed when we were having the Jomo Kenyatta as the president of Kenya, or which year was this one formed? Is it the one that got transformed to the current one?
The initial East Africa Cooperation actually was formed in 1919 between Kenya and Uganda, and then Tanzania, Republic of Tanzania joined in 1924, and then it went and collapsed for some reasons. Then later in 1967, they revived it. And when they revived it, they had different architecture, and they introduced the court, the East African Court of Appeal, which was existing. This statement is going to be important when we are making analysis maybe ahead of this discussion. Then in 1977, the East African Cooperation actually collapsed due to political ideology. I mean, differences in political ideologies, among other things. And you remember that before it collapsed, we had everything. If you talk about, I hear some echo in your end. Could you maybe mute so that no, there's too much echo on your end.
You're getting there. Okay, I'm working on that. So you've said, okay, it collapsed. I understand it collapsed because of some ideology.
Yes. So during that time, you remember within the ESC, we call it ESC because C is constant, cooperation and community is the same. So we had common curriculum, common certification. We had common airlines. We had common monetary, like we had the East African shillings. We had everything was common. All this collapsed in 1977. So now, later on, reviving and all that, which I talked about last. So now, in 1991, so this can demonstrate to you that in 1991 is not the treaty that actually established the EAC. No, it is just to revive and tell or remind the African regions that, hey, there was something that was discussed. We now need to move it forward. Now, each of these regions had a court. For example, most of these regions or most of these, blocks had courts, but others have had challenges that I'm going to talk about. We have the Court of Justice of the ECOWAS. We have the SADC Court. We have these East African Community, or rather the previous court, and also we have other tribunals that were formed. But the rationale for formation is that the moment you come together to have a community of states, or even when you form an association, like in our context, you have a group of people, you come together, you form an association. It goes without saying that you will need a working document that will also outline when a dispute arises. When, for example, we are members of that association, when Kennedy wants to leave, what are the procedure? If one person has a problem with the other, how do we solve that? So basically, court was there to ensure that the existence of these groupings is not affected or is not hampered by virtue of them not able to settle their own disputes. So basically, those were the primary reasons for establishment of these regional judicial organs. But with the time, we have seen a lot of evolution, whereby it is no more just a dispute settlement, but we are also seeing them helping in the interpretation of the regional laws. And interpretation of the regional laws, it means that they are empowered with the supremacy to understand. Because, as I say, when you form an association, you have that constitutive document. So the person who understands it best would be among the committee members who maybe have dedicated their time to understand the architecture or the formation of that organization. So regional courts, we have also seen them extending to that. Another one is that we have also seen them giving advisory opinion on matters that affect the region. So those are basically highlights of what regional courts are. Because of time, we could not delve into too much history, but maybe if those questions
So maybe
come,
just
then
to
we
ask you, you've given some great highlights, and of course, we have been getting to know what we did not know, that these codes used to exist before. You've talked of people having similar currency and doing the same examination. I did hear of it. There's some examinations across maybe East Africa. So, what is the jurisdiction of these courts? Do they are they limited to things that are touching maybe inter-country countries, or they can also be able to deal with things that are in specific countries? Do they limit themselves maybe to solving issues that involve a Kenyan and a Tanzanian, or they can also jurisdict over cases that are involving maybe fellow Kenyans or something like that? So, do they have some defined jurisdiction?
a very good question. And now I'm going to use the East African Court of Justice as an example. And from where I left is that East African Court of Justice, the gatekeeper of the East African Treaty, and this is a constitution that governs the operations or the modus operandi of the region or the East African region. So it has the jurisdiction. First of all, what is the role? As I've said, it has the role to interpret the EAC treaty. It has the role in the application and observation of compliance to the EAC treaty. And it also has the role to give advisory opinion on those matters that may not be understood clearly within the provisions of the EAC treaty. So they have the primary role. So if you take someone to a court, a domestic court, and the matter at hand concerns interpretation of the EAC treaty, you can actually make an application and the matter be referred to the EACJ to first interpret it. Then you bring that interpretation to the national court now to proceed with such specific case. There are very many rare circumstances where that has happened, but still the court has that power to do so. Now, in terms of what we call personal jurisdiction, it is very, very important to understand that the EACJ does not have jurisdiction to entertain any dispute or claim against an individual. No. So it means you cannot take Kennedy or you cannot take Mr. So and so to the EACJ for purposes of trying to raise a claim against him. The personal of EACJ is limited to partner states and is also limited to the organs of the East African community. So you can only sue a partner state or you can sue an organ of the East African community in that court. Now, who has the standard to stand before the court? Who can sue in that matter? Who can sue? The person who can sue now, that is where the ESJ, gives it, easier or makes it easier, and that's where its role in the integration is important, because there are only three categories of persons who can sue within the ESJ. Any resident within a partner state can file a case with the ESJ. So it means it does not matter the nationality, as long as someone says, I'm a resident of this partner state. So it does not say a citizen of a partner state filing against a partner state or against the organ of the ESC. So any resident, that is one. Two, a partner state can also file a case against a partner state or against ESC or any ESC organ. And then three, we have the secretary of the ESJ, of the ESC, sorry, the secretary who is the head of the secretariat can also file a case. So those are the three categories. So I've clarified two things. subject matter jurisdiction and material jurisdiction limited to the matters that relates to the ESP treaty. So you cannot take.
Maybe a question
Yes,
of
please. Go ahead.
clarification. It said that you cannot sue an individual, but you can sue a partner state or something like that. So that one, does it mean that there are specific cases that can be sued? Because there are some cases that maybe there are some offenses that people will commit as an individual, but not as a state. Things like criminal activities. People do commit criminal activities as an individual. An individual have maybe have come from Uganda and is involved in some maybe stealing or some robbery or such kind of things. So in that case, who do you sue? Or does it mean we have specific maybe cases that are dealt with at the same court?
You see, that is comes to material jurisdiction, where now we say what kind of cases you can bring before the court. The court does not have jurisdiction to entertain any criminal proceeding or criminal case for that matter. It does not have that jurisdiction because, you know, the purpose of the court is not, because criminal matters are matters of, you know, national, they are matters of national interest. They are matters of at the helm of the government of each country or each state to make sure that they weed out those criminal activities and make sure that the law and order is maintained. So there is nowhere at the regional level where that has been delegated within the ESC framework. Then another thing is that you have mentioned a very good thing. What if an individual makes a decision and therefore you feel that this decision, or rather this particular action, could be maybe referred to the EAC, or East African Court of Justice. If this person has made this, remember, a partner state is a juristic person, is a moral person. It's invisible. So there's no way you are going to touch, for example, Kenya with your hand that this is Kenya or this is Uganda. So Kenya, you go to the court. And so always partner states, they have what we call the state agents, you see. So as long as you identify that someone has made a decision in his or her capacity as an agent of the state, and that decision has actually affected, or rather is infringing on those specific rights that are protected within the treaty, then you have the leeway, or you have that room to go and now sue the government. When I talk about partner states, you are suing the government for the acts that their agent has committed, which you believe infringe on those, you know, provisions of the treaty.
Sue the government for the act that you're agent. So like citizens are now agents of a specific government. For example, if you commit a crime, then your government will be will be taken to court on your behalf.
Please, as I've said, let's not give an example with the criminal matters, because the ESCJ does not have that particular, you know, material jurisdiction. We talk about material jurisdiction, we talk of the type of justice that you know, a court may administer. So that one, don't give an example. Give example, for example, there are those rights that are protected. Maybe I can give you a number of them, so that when you give examples, you give accurate examples to enable us, you know, demystify this particular subject. So let's say that you are going to import or export some items from Kenya, items that are actually made in Kenya. You want to export them to Tanzania, or you want to export them to Uganda. And the government of Kenya is imposing for you, or to you, some export levies that are not justified by the law.
Okay.
Because matters of internal tariffs that determine the exports and imports within the ESC member state or partner states is a matter of regional interest, or a matter which is protected by the what? By the treaty. Let's give an example that you are prepared, you have an opportunity to go and work in South Sudan or in Uganda. And you reach the border, either if your government is the one now frustrating your movement to Uganda, or the government of Uganda frustrating your entry to Uganda without any reason
Yeah.
justified by the law, that is a matter of regional cooperation. That's a matter of regional integration. So in that matter, you'll be able to. If you also believe, because as I said, if you look at again subject matter jurisdiction, you have seen. I
Yeah.
want to give an example because this is a case that has been settled.
Yeah.
And I want to give an example of the Martha Karua case, and that example would help us understand how sometimes. Uh, just 1 minute. Yeah. So basically, in those instances, you find that if you look at that case of Martha Karua, you find that if uh, your rights or certain rights that are protected by the Kenyan Constitution are violated, you may have audience before the court, but it requires that whoever is going to file your, you know, uh, whoever is going to file that particular case within the court must really understand the framing or the framing of your case, because the court does not hear constitutional matters as well. It's not a national court. Constitutionality and constitutionalism is a matter of national law. So now, if, for example, the Mother Karua, she was claiming her right to fair trial was infringed, within the EAC Treaty, there are those rights that must be protected by each partner state. Those rights include the right to fair trial, good governance, and those rights actually that have been enshrined within the Banjul Charter. Banjul Charter is the African-wide instrument that protects human rights. So if you frame it that way, then you can still find audience. So some people would also want to ask, does ESCJ have jurisdiction on human rights? It's a question of yes and no, depending on how you file that case. Now, those are kind of the examples of cases that you may refer, or you may file with the ESCJ. So it's not about the criminal cases. You can now proceed.
That's really, really fine. Of course, you've mentioned the issue of Martha Karua. And when maybe we talk of these regional courts, we also having our own courts. Like in Kenya, Supreme Court is the apex court. So when somebody, after getting dissatisfied in Supreme Court and goes to the regional court, does regional court have got power over our local courts, or they just substitute to what we have already?
Wow, a very good question, and this is a question that I wanted you to ask, because the Supreme Court of Kenya gave an advisory opinion, I think 3 weeks ago, if I'm not wrong. And in that opinion, there was this case after Martha Karua had won. She came because the decisions of ESCJ depend on the mechanisms of the national legal system to be implemented. So as Martha Karua came with the case to be implemented after she got a good judgment, and therefore the Attorney General of Kenya went to the Supreme Court and sought for an interpretation of the role of the ESCJ vis-a-vis the decisions that have been made by the Apex Court of Kenya. And the outcome was the Supreme Court of Kenya made uh, an advisory opinion that though there is no vertical relationship between those two courts, this is something which is legally sound, and of course that is a very clear and very accurate interpretation. However, we need now to, from where we sit, we need now to understand what would be the relationship between these two courts. Yes, they don't have that vertical relationship, meaning you cannot exhaust the court system or their the dispute settlement mechanisms within the national system, like Kenya, and then you say, now that I've failed, I need to go to the ESCJ. No. Remember, I said we no longer have East African Court of Appeal. We have East African Court of Justice. In the previous, for lawyers who practiced during those days between 1967 and 1977, yeah, they would exhaust all the mechanisms and then now they would go and appeal. But with the current framing of the East African community, that is not the case. So what happens is that these two courts, rather these two systems, because now we have what we call two legal orders, and the two legal orders or two legal systems, they are supposed to be supporting each other to achieve a specific goal. One is that the regional court is there to protect the interest and also to defend any matters regarding the regional integration, which I've given examples. At the same time, the national courts also have been delegated some of the elements of protection of the regional integration. For the ESCJ, I've explained. I've just explained in a few minutes ago. Now, for the national courts, if you look at matters to do with a common market protocol, especially on matters like movement of people, I was mentioning, if, for example, if you go to, let's say, United Republic of Tanzania, and because you are supposed to have certain benefits, for example, you are supposed to be given entry without paying anything. Yes, that is the framing of the regional law. And now you find that you are subjected to pay certain amount so that you can enter any partner state. This is a matter that, if you look at the Common Market Protocol, within which is a protocol as a constituent of the ESC Treaty, then you have the courts of the national courts have the power to entertain such complaints. Remember, now we are talking about the regional matter now being taken to the national court. In that context, the national courts play a role to support the regional integration. And at that point, also someone would ask, do we have, let's say, now the right, or do we have the leeway to seize either national court or to seize the regional court? That is what we call concurrence. In some occasion, of course, very exceptional, we find that a matter can still be entertainable within the ESCJ at the same time within the national court. So what makes the difference? The difference is it's made based on one, what we call the forum shopping. That time of forum shopping is where you say, okay, where would I get a more favorable outcome when two matters are able to go to national court or to go to the regional court. For example, the Martha Karua case, let me give a practical example. The reason why she went, or rather she felt that maybe the Kenyan system had not given her the right, or had not, granted her wishes. And then now she went to the regional court, right? Yes, that was it. However, if you look at it, reason why now the Supreme Court had to come back and make or clear it very well is that it would create perception that she waited until she did away with the highest or apex court, then now she went there so that she would veto decision of the Supreme Court, which must not be, and is not the case if you look at the framing of the ESC Treaty, or even the functions, or even the powers of the East African Court of Justice and the National Court. So if, for example, an advice, if there may be any lawyer who is watching this, if Martha Karua maybe had wanted a proper maybe way in which to utilize the existence of the ESCJ, at the point she had gotten, let's say, a technicality, or rather that decision that was made by the High Court, at that particular point, she ought to have, referred the matter to the ESCJ, so that it does not appear that she is now exhausting local remedy and now going there to veto the apex court. But probably because within the ESCJ rules, if a matter becomes like, if you, let's say, establish a matter that requires you to go to the court, you have 30 days. So maybe the lawyers, our lawyers had seen that maybe the 30 days had elapsed, and therefore, or something of that kind. But that is the reason why the Supreme Court came out very clearly and said, no, we don't have parallel jurisdiction. That is a protectionist judgment, or a protectionist advisory. Because remember, as we talk about regional integration, Supreme Court of Kenya, as the apex court, has that mandate as a gatekeeper of your sovereign power. You as a Kenyan had a sovereign power and a gatekeeper or a guardian of the constitution. So anything that would eat into the sovereignty of a country, they are at the forefront to do everything in their best knowledge to make sure that they keep it as such. Reason why that comes is the nature of our integration at the East African community. There are two levels, or rather, there are two approaches, or there are two models of integration which are mentioned in other media appearances. We have the supranational, like when we talk about the European Union, where now they let their sovereignty go, and then they trusted that sovereignty at the level of the regional level, which is the European Union. In our case, we are not there. We are in what we call the intergovernmental integration model, whereby each partner state still retains its sovereignty. So there is no point, there is not at any particular point when these sovereignties, as we talk now, when these sovereignties could be maybe laid off in favor of any regional organ. It is not very possible, and that's why Supreme Court came out very clearly. So, but again, we need to learn that that decision does not render ESCJ useless. ESCJ can make certain decisions that will help any person, as an individual, or as a country, or as a partner state, or even as a region altogether.
Thank you. I think that is really clear. And maybe because you have mentioned and you're using the East African Court of Justice as a practical example, I just want to ask you this: what is the composition of this court? How do they like get their judges? Does the countries contribute maybe a specific number of judges to sit in this court? Then, secondly, on the same, when the countries become member, I know you've already told us that membership of the East African community, there are countries that joined later, like Rwanda and Burundi, and of later, late last year we saw Somalia are joining. So when a country joins, like Somalia have joined, do they automatically adopt the practices and the systems that are there? Like if you are in Eastern Africa, currently you are expected to be moving visa free. But if you go to a country like Somalia, still they've not implemented that. Do they have a grace period so that, or maybe when you join the EAC, there are some things you choose what to adopt or what maybe to sign? Like we talk of the Rome Statute, the one that created the ICs and such kind of things.
Of course, this is not Rome Statute, but we have the treaty. Treaty is our tool. For the first question, yeah, the structure of the court is also important to know, because that also emphasizes the fact that the court is not an appellate court for the national or domestic, tribunals or judicial organs. So the court has two levels. We have the first instance level, and then we have the appellate level within the same court. So you can see it has its own structures. So when you are making a reference, the language we use when you are filing a case within the ESC to differentiate it from the national procedures and all that, we say you are filing a reference. You don't say you are petitioning or whatever. You file a reference, or you are seeking an advisory opinion. You understand? So now, if anybody who files a reference at the court on a matter, on a claim, definitely files it with the first instance. Now, if you get a judgment, which you feel is not favorable to you, or if you are dissatisfied, then you have now to go to another level, which is the appellate level of the court. It's the appellate and the final step of that court, or the East Africa Court of Justice. Now, judges, yes, as per the EAC treaty, judges are contributed, or rather are released from all the partner states. EAC treaty says there's that principle of equal representation. So most of the times in all organs of the East African community, there's that requirement to ensure that membership to each organ have that equal representation across the member or the partner states. So yes, the judges come from the partner state. I won't go much on that because there's an active case where Kenya nominated one of the persons to be a judge, and I don't want to go into this because it's a matter with the Kenyan court. But I would say that as a partner state nominates, there are those rules that govern nomination. So you cannot just front anybody. So the person, for example, must be a person of a caliber of being a high court judge in any partner state. The person must have practiced law and therefore is known as a person of good standing, and the person who is perceived to be has not be violated certain basic principles in the justice system. For example, ethical aspects. Someone who has not been indicted in those serious matters of public concern, and among other rules that apply. So yes, they are coming from there, from each partner state. Remind me your second question on that.
My second question is a simple one. Like when these partner countries join, like you join EAC, do you adopt
Yes,
all the
all right.
there?
Yes.
I think
Yeah. First of all, now we have 8. Actually, we no longer say Rwanda and Burundi joined recently because we have examples like South Sudan, we have DRC, and we have Somalia. But what does it mean to join? Joining EAC is a rigorous process. So once a country makes an application, then there are those what we call verification procedures, which entail visiting and some, check boxes to be ticked. If you look at the EAC treaty, I'm afraid I don't want to quote the law because I want this conversation to be as simple as possible. So the EAC treaty sets the threshold. For example, if a partner state or any prospective partner state must make sure that they are put in place, structures of good governance, human rights, and all that. Of course, whether those ones are applicable is a story for another day. But now we assume that now as they are being admitted, so ceteris paribus, other factors remain in cause. So we assume they already met those thresholds. Now, as soon as they join, remember when we talk about the regional integration, it is driven by a number of instruments because there are so many levels, there are so many areas of cooperation, and each of these areas of cooperation, there must be certain instruments that we need to rely upon, and then the partner state must access to this instrument to ensure that they also adjust their national laws to do what? To support this. I want to start, for example, the first pillar of the East African Community Integration is the customs union. Within the customs union, there are those requirements. For example, we must have common external tariff and common internal tariff. And common external tariff, it states that any good coming from any country or any territory outside the region, if they are exporting to East Africa or any person is importing to East Africa whether they enter through the port of Dar es Salaam, whether they enter through the port of Mombasa, whether they enter through Kigali International Airport, whether they enter through Entebbe International Airport, the tariffs that apply should be the same so that we don't create trade imbalance. The dangers of not having the same within the the rationales of the customs union is that if, for example, rate is 35% for all the importations from external territories, then a partner state charges 25%. So it means they will look for the partner states with less charges. They bring the goods inside, and then now they start supplying within the region, because within the region there's that common also internal tariff. So that is the rationale. Now, if a partner state joins, then the partner state had in its own, laws or finance act that says that our imports are, let's say, 20%. So they are required now to review that particular law to align it with what we have at the regional level. Now, when it comes to common market protocol, which is another pillar, second pillar, it requires that every partner state must give free entry for a citizen of another partner state. The treaty requires that, the protocol requires that a partner state must give up to 180 days, six months, visit. You see? So now, if, let's say, a partner state joins, let's say DRC joined, so it means that if they had imposed entry visa on a Kenyan or on a Tanzanian or whatever, they must align their laws to make sure that they remove those particular visas. So those are two examples. So what does that mean? It means that when a new or a prospective partner state comes in, they are given what we call reasonable time, to make sure that they work around their internal laws. So this process requires a political backing, because lawmaking is not a one-man's show. You just experience the Kenyan, or rather, we have the Kenyan experience of Finance Act, or rather, Finance Bill, quote unquote, and you see how much it takes just to make law, especially laws that go into taxes, laws that goes into levies, laws that the money, what we call the money bills. So now these partner states, we don't have a reference point within the EAC rules that says they must do this thing within this particular. Of course, when they meet as a summit is all the heads of government or heads of state from all partner states. They try to have a discussion and say, please, we need you to do this, because the secretariat, the EAC secretariat also propose, say, okay, could you do this within, let's say, 3 months or 6 months or like that. Now, after they say that, remember, I said we are dealing with countries that still hold into their sovereignty. So it's upon those particular states to come to bring about those changes in order for them to integrate and catch up with the rest of the parties. So at times we find that others move quickly. For example, Rwanda is one of those that move the fastest in terms of incorporating the EAC laws, and even today. And I see someone has actually made the same comment. Rwanda has done that one, and is a good practice, and is one of the partners that we can point out to. So now Rwanda has done it so well, but remember, without any prejudice, the areas that Rwanda has done so well, we have other partner states that have been there since time immemorial. We have United Republic of Tanzania, we have Kenya, we have Uganda. There are certain areas that they have not effected, yet Rwanda joined and found them when they are within that integration. So there's also that political aspect of it. But basically, that is what happened. They are expected to align their laws. They are expected to make sure that they join the integration, and they make sure that they make the integration work by allowing their citizens to enjoy, or even other citizens from the other partner states to enjoy. However, sometimes it may not be true. And that is where now the ESCJ comes in. Because the moment they ratify, because before they make their national laws to align with the integration framework, they must ratify those protocols. For example, customs union protocol. So now, if you as a citizen, or you as a resident of Kenya or Tanzania or Rwanda, and you feel that South Sudan is taking too long to allow visa-free entry into their territory, you just go and check, or you ask an expert like us that have they ratified Common Market Protocol? Then we say yes. Then you just go to the East African Court of Justice and you sue South Sudan for them not trying to, make their laws easier for you to enter there. So that is now where now East African Court of Justice becomes a gatekeeper. All right, thank you.
I get you, and thank you so much. Of course, somebody who asked that question, I think, is now answered because the worry was that they still pay visas, yet they had that the countries join EAC. So maybe a quick one. I think you've talked of it on how the composition of the court. I want to be represented in the East African Court of Justice. Like, let me use the case of Martha Karua. Which kind of lawyers do I pick? Do I go and pick my local lawyer, Murkomen, over there, or I go and pick somebody like Jimmy or Professor Kidiki? And like, in Kenya, we have people get admitted in the bar, and they have some licenses that are being renewed with the Judicial Service Commission and all those law societies of Kenya. So do we have such kind of organizations within Eastern Africa that admits lawyers, or within the regional court that admits lawyers or advocates that can be able to maybe represent you in their courts, or anybody else from different country can just walk in and represent you as an advocate?
A good question. First, let me just clarify, or rather strike off a statement. Judicial Service Commission has nothing to do with the certification of lawyers, so that should not be accurate reference. But it's true that an advocate must be a registered advocate. It must be an advocate of good standing with the national body that regulates the practice of advocates. And in Kenya, we have the Law Society of Kenya. So anybody who is in practice and in good standing in a partner state has the privilege to represent any person within the East African Court of Justice. Is it answered? Must be a practitioner, must be in good standing within the partner states, and therefore you'll be allowed to represent any person or any matter before the court.
I get you. So you said anybody can be
No,
able
not
to
any advocates. Any advocates.
any
Not
advocate,
yes.
any
That's why
advocate. But there's a question.
yes, yes.
When I look at when you are Wakili, but when I look at lawyers, we have people who they tell you, I've done international law. Maybe there are different degrees, or maybe different levels, or different departments that people concentrate in. So, for example, somebody who's just done the law within the country, maybe within Kenya, do you mean that they practice similar laws? Because I do hear somebody like you've done international law, so meaning you understand the jurisdictions outside the country and maybe something like that. So, is that or not maybe affecting such kind of representation? I want to give you a case study, for example,
I
some
wish
time back,
before you
seven
bring your
to
case,
eight. Yeah.
I think that's a it will be a very insensitive area for me to delve in because the practice of law is a very sacred area, and I believe it would be not appropriate for me to discuss which kind of lawyers would be able to stand or not. The moment someone is a practitioner, it's assumed that they are all capable of representing anybody. They have the skills, and that's why they have passed all those levels of academia, the professional course, until they have been issued by the license to practice. So there's no any other argument insofar as who is.
You're trying
So let's shift to the interpretation.
People decide how to specialize. Do you mean that people decide to specific areas, and the fact that they specialize doesn't mean that they cannot maybe tackle other areas? Because we have relationship lawyers, we have property lawyers, we have constitutional lawyers. So maybe make me understand.
This is a question you can have one-on-one with your lawyer, and your lawyer will be able to tell you whether he or she is fit to represent you on a given matter. But it cannot come from me, and even if it comes from a third party, that person will not be, giving you any content or rather any information that you can rely upon. So it's an area that does not really, does not have a scale. Yeah. So the assumption is, which is a very accurate assumption, that as long as someone is practicing, that person is capable of representing you. Whether they are good in that or that is a personal decision, just like a medical doctor. Others, general physicians, but also cannot speak on their own behalf. But we can go to the integration.
I get you. I get it. Okay. So maybe you can elaborate to us, like, okay, you've really talked of the ESC, and do you have a certain regional court that maybe integrates the entire Africa? Because you've talked of the ECOWAS having theirs, the SADC, the East African Community having theirs. So do you have one that combines maybe the entire Africa?
Yeah, I began with that one
Similar.
actually. I said that we at the African level we have the initially we had two courts actually. We had the African Court of Justice, which was dealing on those matters concerning dispute settlements amongst the African states, and then we also had the African Court of Human and People's Rights, which was dealing with on matters of human rights. And I believe it has really done a lot of work, which anybody else who is keen on this subject will be able to bear with me that really the court has really performed. Now, towards I think early 2000, 2004, coming up to date, there were those discussions that it was overbearing for Africans to run the two courts because even within our country at the country level we still struggle to even finance our budget. In fact, I think 80 or even 90% of African states have fiscal deficits. So as they draw their budget, there's that space that they still wish to have grants or something like that, whatever, an external borrowing, so forth. So it means that even at the national level, even at a country level, we still have not enough. So if we are supposed to contribute to this code, where are we going to get to contribute to two of them when we are struggling? And that actually affected the operations of some of those two courts. So the idea came, and now the merging of the two courts are on course. So now we have them. It's African Court of Justice and the Human Rights Court, or African Court of Human Rights. Actually, it's going to be called the African Court of Human Rights and Justice, something like that. So yes, we have that, and they are specific, of course, in terms of their role. I've said one was dealing with the interstate conflicts, especially when there would these border issues, like the matter of Migingo. Let me give you an example. That the matter of Migingo
Actually, I was to
following.
ask you that because we have
For,
this court and we are having the issue with Bingo.
yes, but probably we do not refer it to African Court of Justice because maybe we knew the court was struggling. If it is not financed, how will it operate adequately? You also saw we had a case with between Kenya and Somalia on these elections,
Yeah,
but for
we had a
them,
case that was ICC, if I'm not wrong.
no, ICJ, International Court of
Yeah,
Justice, not
ICC,
ICC.
sorry.
Yes, ICC is also criminal court, but at the international level. We also have at the international level, we have the ICJ, which is the International Court of Justice, that deals with disputes between amongst the members of the United Nations or countries who are members to the United Nations. So now, if you look at the Somali Kenya, they chose ICJ because basically this was involving international maritime. So someone would say, why did they go to African Court of Justice? But the ICJ was the appropriate forum because it involved conflict over an international maritime, and of course, even borders between Uganda and Kenya, like Migingo, has that international nature, but we construe it to more of a cross-border or a regional matter because there are those levels where we look at Africa as a region, not as international. So so those ones were Migingo was fitting before African Court of Justice. Now the matters of human rights or the African Court of Human and People's Rights are those matters like we had the demonstrations, and you see we have police being accused of infringing the rights of persons who are demonstrating peacefully and all that. Yeah, those are matters that can be seized before the African Court of Human and People's Rights, and the court sits in Arusha, Tanzania. So that court has done a lot, and therefore we have those judicial organs at the level of the continent.
Thank you so much, Wakili. Of course, we are really getting to learn a lot of how these regional courts can integrate the African agenda. So maybe just in your own view, you know, these courts you've said historically they've been there, they've been making steps. Sometimes they get dissolved again, they come back. So where do you see these courts maybe in the next like 5 years towards maybe these sustainable development agendas that you're having? So do you see them getting better, or they've lost relevance?
I think for the for East Africa, like the East Africa Court of Justice, I think the court is gaining relevance day by day, and that is why you see we haven't had this advisory opinion on a matter that touches on a decision that was made by the court. And as we talk today, without going deeply, there are so many references that have been filed by individuals from Kenya, from the region, from other partner states. If I'm not wrong, I think there's a reference filed by Grand Mullah, one of senior counsel from Kenya. There's another reference filed by another politician in Kenya, who also thought that his rights were violated during elections and not being given ticket to buy and so forth. And you see, those are things that tell you that people begin to recognize. And now, even through this kind of platform where now we are discussing this code, probably someone would be able to now to know how do you even make a reference to East African Court of Justice, or how do you file a case for that matter. So, as I said, the moment you have established that you are right, that you feel is protected under the EAC treaty, has been affected or has been infringed by a partner state or by an organ of the East African community, then you have, as per the 2019 rules, if I'm not wrong, you have 30 days. Within 30 days from the time you establish, to file a reference with the court. And the outcomes of the court are not, we cannot say they have no effect. They have effect. People should not misinterpret the advisory opinion of the Supreme Court of Kenya, whereby they said that the decision of East African Court of Justice in that instance had no legal effect. It's just because that the filing that was done, it was done to, it could appear that it was done to appeal against a decision of Court of Appeal, sorry, or Court of the Supreme Court, which is a different case together. However, if you make your filing very, very well, and I've said there are things that you do even within our national territories that you feel that the government is supposed, for example, distribution or redistribution of resources. You see, so if you feel that your area has been marginalized and therefore the government is not doing enough to support your area, that is where now ESCJ comes from. If you find a way in which you can frame it within the East Africa Treaty. Why am I saying that? Because there are those cases, and this is very important. I talked about concurrence. There are those cases whereby the national court would be having competence at the same time the East African Court of Justice. But you are looking at the political power. You are looking at the position you are, and ordinarily or ideally, without trying to prejudice or something like that. There are those matters that if you feel you may feel that if you take them to the national court, your rights will not be addressed very well because you fear political interference, you fear bureaucracies, and even looking at time, the regional court, the East African Court of Justice, dispenses its cases faster than even the national court. So at the moment where you find concurrence, where you find that this is a matter that can be addressed by the regional court, you will obviously refer the matter to the regional court for purposes of ensuring that your rights are settled as soon as possible. So this is a court that is going to gain more relevance, and it is going to be very important, and is the one that is going to keep what we call the regional integration, particularly for the East African community, as we are moving forward to implement what we believe is good for our people.
Thank you so much, Wakili. Maybe I just have this concern. We've had so many African leaders being taken to the International Criminal Court, that is the ICC, and whenever their cases are being taken there, they say that the court is against Africans. Like some of them have a belief that the court was made for Africans because they don't see their counterpart maybe from Asia, Europe, or America being taken there. And this is a debate that has been widely in Africa, whereby some leaders opt out of the court or they think of getting out of the court. Sometime back in our country, we also had that kind of conversation whereby we were opting of not taking any of our own to that court again. Don't you see that African Court of Justice can take that advantage and maybe redefine their courts of justice, re-establish it, and maybe ensure that their courts are so effective that they don't have to maybe be subject to the Rome Statute?
You see, also the regional courts, the African courts, and the international courts, there is no vertical relations. So we don't have like from African. So there are those scenarios, circumstances that whereby they can have concurrence in very exceptional, events. Um, the matter of ICC and the politics that are made around it is not something that I would really address from an expert point of view. Because you see, politicians will always have excuses, even within the national jurisdictions. They will still say, courts are doing this, courts are doing that. But we need to appreciate that any judicial organ is there to protect the rights that have been committed to. Because you see, from a very layman point of view, the same politicians that would castigate the ICC, they have the knowledge, they have the procedures through which they can pull away from it. You understand? They have all that through which they can pull away from it. But they know at the back of their mind that they are only using it for their own convenience. You see? So those political games have been there time immemorial.
I get you. They are using it for their own convenience. But like you said, the ESCJ is really competitive and is really doing well. There is something that is happening in DRC Congo. There are some injustices there. There is some instability, and one would think, what is these courts doing? Why can they restore some sanity in DRC Congo, or are they not members of this court?
You see, let's look at the national legal system. You are not going to see a magistrate, judge, or justice of High Court or Supreme Court or justice of the Court of Appeal coming to address conflicts that are happening in a particular corner of Kenya. Courts sit so that matters are taken to them. And as a good resident of the ESC, as I've told you, you are empowered by that court. The question would be: have you had any reference filed on those matters? And if they are there, then you should ask me, Wakili, if those references have been filed, what next? I will tell you, okay, if they are there, I may not go on to merit, but I will say, okay, that's a very good step because it is going to enable the court to do A, B, C, D. You understand? Yeah. So we cannot blame the court for things that are happening outside the courtroom because courts do not take matters on their own volition. They sit, the matter is brought. Of course, let me also make a comment. Things that are happening in Congo, they are regional concern and, of course, of international concern because we have also the human rights violations, we have instability, conflicts, and all that. And there was a time I was writing a paper, and a sub-chapter, I mentioned mechanism through which East African community would be able to undertake a few steps in terms of the East African community, not the court. And one of them actually you saw happening whereby they bring the through the what we call we have a protocol, a peace and security protocol of the East African community, and it provides mechanism through which conflict should be addressed. And when a conflict is addressed, we have the eminent person where you saw the former president of Kenya, His Excellency Uhuru Kenyatta, was appointed to lead that negotiation and mediation. Then we also have the East African Community Standby Force. Those are now soldiers drawn from different partner states that can be sent for peacekeeping purposes. You also saw that happening, and I think they were led by General Nyaga, if the title is correct, from Kenyan military, and they were there. They just pulled out, and now I think SADC is there. So East African Community has attempted in terms of their interventions. But in terms of addressing the specific rights, it's a matter that someone will have just to file a reference to the East African Court of Justice. And in that context, we will be able now to see what the court is capable of doing. And I assure you that if that is done, then the court will not shy away from making those very tough decisions.
Thank you. That is clear. And maybe just to clarify on this, of course, you did talk about it, and somebody is still asking. I just wanted to clarify. Somebody is asking on a specific case, the case of Karua against, I think it was the case involving the previous or the last general election. So can these in regional court overturn the decisions that have been made by the apex courts in the member countries? And if that one cannot happen, why would somebody waste time to go to a court that is not going to overturn, have a reference to a court that is not going to overturn the decision that has already been made? Like, why would Karua go to that court when already she knew that the decision made by the apex court is final?
You see, East Africa Court of Justice is not an appellate court. Like, it does not entertain matters because you have been denied right here, and therefore, in terms of the justice system, that you've been denied rights after taking your case on this particular court, and therefore you come. No, it does not operate that way. And technically, I think that is why Karua lost this particular case in Kenya, and that's why implementing, because what she has lost is implementation. Because implementation requires also to follow the law. So now the courts cannot sanction implementation of a decision that has no legal effect. And without maybe fear of contradiction, the people who filed the case for Karua at ESCJ, maybe somewhere along the line could have saved the day if they ought not to have waited to go to the Supreme Court. You understand? So the East African Court of Justice is not the court that is going to veto the decision of any court in Kenya. Actually, if you are going to sue the Kenya, if there's a decision that has been made by a court, because a court is judicial is agent of the state. You understand? Because it's one of the arms of the government. So remember, you are not going there to sue the court. You are going there to sue Kenya for the acts of its agent. You understand? You sue Kenya for the acts of its agents. You say Kenya has violated the provision of the treaty by not administering the right to fair trial. As simple as that. And therefore, as a result of that, I have this specific harm. I've been harmed, I've been injured, I've suffered this damage due to the fact that Kenya, which was supposed to observe the right to fair trial, has not observed through its agent, which is the court. But now, if you go saying that the court has denied me my fair trial, and therefore I feel, because that means that you are actually going to litigate human rights. But the ESCJ does not have explicit right to, so explicit jurisdiction to adjudicate human rights matters. It only does it alongside interpretation of the ESC treaty. This is a bit technical. So it means that the case of Martha Karua cannot be construed, and that is what the Supreme Court of Kenya made clear in its advisory opinion. It cannot be, and it will not be, as long as we still have ESC the way we have it today and our national laws the way we have them today. It cannot be made to be going to make decisions to quash or purport to set aside a decision that has been made by a court in Kenya. Not even a Supreme Court, even a magistrate court, it does not, the East African Court of Justice does not have power to make that step by quashing a decision of a magistrate court. So because there's no vertical relationship, so it means you are not supposed to come from here to go. No. If you believe there's an act that has been done by magistrate court and it has affected you, you go and sue Kenya for not observing a specific provision of the EAC treaty. And that provision, there must be nexus between that provision and the acts that have been performed by the magistrate court or that particular court. The same happens. You are saying that when you file reference, this is another thing. When you're filing a reference in the East African Court of Justice, you are suing the government, and the principal respondent is the Attorney General of that particular partner state. So, for example, that reference is Martha Karua versus Attorney General of Kenya and others, if there are. You understand? Yes. So now, if, for example, what are the agents of the states you can think of? We have the courts, we have the central bank, you know, we have the ministries, you know, we have all those agencies of the government. If they undertake any act that you feel would have a nexus with the violation of a provision of the treaty, then you go and sue the Kenyan government and demonstrate that that act violates the East African Community Treaty. And once you justify that, then now go another level. Prove that now, because as a result, you have suffered this particular damage. So that's now the court will be able to maybe award you damages, because the court has powers to make judgments. But if you look at the way the court makes judgments, especially the East African Court of Justice, it can make a declaratory judgment whereby it says, we certify that this matter, so and so has done wrong. You understand? The Kenyan government has actually violated the treaty. That is called declaratory judgment. Kenyan government has violated the treaty, declaratory judgment. Then there's a second level of judgment, issuing an order or injunction telling Kenya you have done this, or you have passed law which is against the whatever. Then we want you to remove that law. The East African Court of Justice, actually, there was a law that was passed by Burundi sometimes back. This law was regulating media, and it had a provision that stated that if a journalist in Burundi has aired an information that the state feels is insensitive or is against the public security, then the state can compel the journalist to reveal the source of that particular information. You understand? Or the journalist will be incarcerated or will be prosecuted. They felt that this law is against certain principles of the EAC Treaty. Freedom of media, freedom of expression, what, and all that. Now, they went to the EACJ. EACJ made first a declaration that indeed that law infringes the EAC Treaty or the provisions of the EAC Treaty, to which Burundi had committed to respect. Two, it made an injunction, it made an order that Burundi repeals that law immediately. And maybe if they had gone ahead and said there was a journalist who was maybe incarcerated and all that, or incurred damages as a result, or maybe instruments confiscated, the court would also go ahead and award damages based on that. So that is how the regional court operates. So you cannot go and start saying, my right has been violated. It will not help you, because
it must be with the regional statutes, yeah?
Exactly. And regional statutes here, we are talking about the treaty, you can talk about the protocols, but those protocols, you must also interpret them keenly, because I said in some protocols, the implementation framework has been delegated to the national courts. I've just mentioned customs, I've mentioned common market. So as you interpret, you must know that give the court what belongs to it. And therefore, when you get
I get you.
Go ahead.
I'm saying I get you. That is well explained, and I think, ladies and gentlemen, the ones who are viewing this, that is Wakili Kennedy Abuya. trying to explain to us the regional codes and the African integration. Of course, it's a very good evening, and we do appreciate you. And maybe I know we are not going to talk about this. I know one of these fine days I'll call you to come and tell us something on the budget making process. You know what is happening in the country right now. We are making a budget, of course, and we are in the process of making budget. This is something that has been happening yearly. But this year's budget making process has been marred with a lot of opposition and some protests. And if you can look on the streets on your screens, you can see the youths. They call the generation Z. They are the ones who've taken out to the streets to protest the budget making process. And for the first time, you'll find that we are not having politicians leading this, but we are having citizens against the politicians. So does this one mean that Kenyans or the younger generation are waking up and they are taking responsibility and they've lost hope in the politicians? I think you did watch that, because some of them, they don't even understand the process that is involved there, but they are vehemently opposing it.
I think it's too soon to make this judgment. Actually have been watching and observing as a good citizen, because these are matters that also affect us directly. It affects me directly, and therefore I'm a stakeholder, just the way you are, and those our good brothers and sisters, the Generation Z, as we call it, Gen Z. Yes, so particularly it's not about understanding, because it requires very little to understand that certain things are wrong. So they don't need to go to class. They don't even need to have a seminar to be told about the budgets, or rather the taxations or the taxes that have been imposed. It doesn't matter from which angle do they get the information, but as long as they have been informed and they believe, or you believe, that there are certain things that you feel are not right, then you have unfettered, right to basically, protest, of course, peacefully, and express your displeasure in a peaceful manner, in a way that would compel the policymaker to reconsider their position. Now, the introduction of the young generation into Kenyans' agitation for their rights is something that unprecedented, because for the last few days, you have seen, and I think media has done a good role by trying to justify that this is really is not a matter of the old, it's a matter of young people. And we have seen them being interviewed. They are talking out their lungs. They are saying all that. But this could be a hit of the moment, because good liberators don't do it for 2 days and stop. So unless we see them, sustaining this for this particular number of days, or this particular number of months, and until we see also, because as you communicate, communication has two ways. If I communicate and I don't have feedback, there's no communication. So right now there's that communication going out. But until they do it in a sustainable manner, or in a sustained manner, not sustainable, sorry, in a sustained manner, to the extent that we shall conclude that really we have a generation that is out to make sure that they get what belongs to them, what is right, and what they feel should be, as they wish, as good, people of that this particular, or our nation. And then after they make a sustained effort, are we going to see feedback? Are we going to see the policymaker coming out and addressing those concerns? Because if we see that, then we say Gen Z, they have really come out, they are really doing a good thing. And I'm not saying that because of any reservation about whether they're doing it for TikTok or whether they're doing it for
No, we did.
Twitter.
We did. Yeah, somebody said some of them are just doing it for fun, doing it for
Yeah,
TikTok. For
yeah.
this
So
one doesn't mean
actually,
that. Yeah.
yeah. So at this moment, it's difficult. So anybody who says something, they may not be wrong or they may not be right. So for me, my yardstick would be, if the Gen Z does this in a sustained manner, but which requires time, then we'll be able to say, okay, fine, this is really a different paradigm shift in terms of citizenry empowerment. And then after
Yeah.
that sustained level, then we will also see the policymakers, because obviously, if they have sustained it, the other end will not have any other choice other than coming out to address. So I think that is basically that's what maybe I can give as my observation regarding the unrest in Kenya with the Gen Z
You
party.
talked of something called a liberation, and there are people who also say that no, this is not liberation, this is sabotage. So, what the difference between at what point do you say it's sabotage and at what time do you say this is liberation? Remember that Kenya is a business hub, not only for Eastern Africa but for Africa. And when it comes to regional integration, most of these countries in Eastern Africa do take Kenya as their elder brother. So, don't you think that we're Kenyans are giving maybe some bad example to their peers or their younger brothers like Uganda, Tanzania, Rwanda? Because if maybe these kind of things proceed on, then we are going to see these other countries, these other regions also doing the same at particular time when they are having their budgets being drawn.
Kenya is a very old democracy in terms of looking at the steps we have taken, and in public international law, when we were introduced to the concept of statehood, and there's this question that arises: is one state better than the other? And we say, or the answer always arriving at is that no state is better than the other, but only on specific aspects. So, in terms of democracy, I think Kenya we have an upper edge, and it's not something that would be copied by any other state, because it has taken so many or so much in terms of sacrifices, that people have made to put Kenya where it is. For everybody to have a right, for people just to come out, shout what they want, go to their homes, and that is one. Two, it is indeed true that Kenya is a business hub and a gateway to the region, East Africa, and also gateway to to Africa as a whole, which is true. You saw the other day, Kenya got elevated by the current U.S. President Joe Biden, uh, by stating that he has no reservation, putting Kenya as a non-NATO ally. If you know or if you understand the international relations, and the statement, or a statement that would you know say that Kenya would be a non-NATO ally to the US, you will analyze it deeper and see that that status were not given if there is no reciprocal gain. We say always that there is no free lunch. I don't think things have changed whereby we could get free lunch from US. So Kenya is a very, very critical and is a very, very strategic partner to some of these world largest economies. And as we do this, there are two ramifications. One, we run the risk of scaring away the investors, especially, such like things, they have the potential to lead into lawlessness, anarchy, and all those sorts of disorder, which is not a good environment if you want to trust persons like Elon Musk to bring us, some of Tesla's, assembling plant in Kenya. These are not good stories if you want to attract the Tata that purchased the rovers and all that to also extend, their investments in Kenya. So we actually run those risks, but again, those risks cannot outweigh the fact that Kenyans want to live well. Kenyans want to go to their houses when they don't worry about their health care. Kenyans want to go about their businesses when they don't worry about insecurity. Kenyans want to, look for jobs and find jobs that suit their qualifications, not someone studying engineering or any other, very, skill intensive course and is unable to get employment. It is the responsibility of the government to create enabling environment. They cannot employ everybody, but the government should be able to facilitate and make sure that everybody gets something at the end of the day. And Kenyans also want that when there is time to take their kids to school, they have some surplus in terms of savings. So the government should not eat all their savings. How will they sponsor their kids to go and study? Because government does not pay everything. They just support to where they are supporting. Parents have obligation to pay. So those are the risks that we are running. They are there. But we cannot also not forget that there's something that needs to be done, which Kenyans feel is not being done right. So those are two evils at the same time, or the dilemmas that we may not run away from. But either way, we must commend the direction in which people now come out and share their thoughts openly in Kenya. Of course, we also have to condemn those um, uh, those instances where people are expressing their displeasure are not addressed in a manner that solves their problem, but addressed in a manner that um, exaggerates their situations and making it even more difficult by deploying police who are not able to understand that these are people who are not there to harm, they are there to just express their discontent about what is going on. And if you talk about Gen Z, those young men and women, I don't think they were having guns. And in all circumstances, it is not appropriate for us to see the level of force that was deployed to, the extent that we have been losing, fellow Kenyans. We are also aware when we have casualties from the other end. It's also unfortunate, but at least if the situation is handled in a professional manner, we will not have casualties in all ends. We will not have casualties from the law enforcers. We will not have casualties from the Gen Z or the demonstrators. So I think it's a lot more. We need to be tolerant. Our leaders should not just repel, whatever comes. They need to be tolerant and find different ways of it. Because Gen Z, they are coming. They are millennials. They are coming with different ways. So also find a way. I wish if they were in leadership, I was in leadership position. This was the right moment for the government actually to seize and make sure that they bring a different way of engaging with this. They would have even announced for seminars or another public participation, whereby now they even go to the universities. Public participation they are doing in this town halls, counties. The government should now think of putting public participation even among the universities, so that if there's a budget process, go to the universities, get their ideas, because these people think beyond what you thought they were thinking about. They are
But
thinking about the ideas of the university.
maybe do you think we need to blame our maybe constitution, which just talks of public participation, but maybe they did not define the threshold of public participation? Because you'll realize that in this bill, they'll tell you public participation was done, and they'll give you the minutes, and they'll give you the photos, or maybe such kind of things. Could this one be the reason why people will just sit down and say, okay, you call some friends and say, okay, we've done a public participation just for legal purposes, but in real sense, you didn't meet the real people who are supposed to give their views.
Actually, you are right on this, because the constitution has no problem. The constitution is agronom. It's just that gives us the element, things, the basics, the fundamentals. Those are the things we get from the constitution. The rest must be implemented through other laws. For example, in Kenya, as so far as I'm aware, we had a public participation bill in 2023. I don't know how far it is, because if you look at that public participation bill, the reason why it was enacted is that we have had so many laws that have been quashed by relevant courts because there was no public participation. But at least there are those principles, what we call general principles, that guide what we may say a proper public participation. One is that the people concerned, the people or group concerned, must be consulted. They can be consulted through their representatives in those groups, not through parliament. I'm talking about now, not representation at the parliamentary level. For example, if you are talking about a bill that is going to affect women, for example, taxes on sanitary pads, you need to make sure that that group, a representation of that group, have been consulted, they have given their views, which have been considered in that particular tax. You are talking about creative economy and all that. Make sure those who are in there. So those are the basics. However, it is true we have a gap. The gap we have is that we do not have a substantive Public Participations Act. The last time I checked was 2023 bill. I don't know if it has been passed this year, then maybe I have not seen it. Or if it was passed late last year, I have not seen it. So I agree with you. The threshold of understanding public participation is a miss. It's not a problem with the constitution, but we require another legislation to put it very clearly. But should we wait for a legislation to do something which we believe we can achieve even through application of logic? We don't need legislation. If you are going to increase school fees, Education Act, or in any other manner, those who are at the university, they are all adults. We have not seen them going there, discussing. So now you see, most of those, the Gen Z, the ones out on the streets, they're university students or they're university graduates. They are expressing things that affect them directly. So we don't, even if this legislation has not been there, we still blame the policymakers. How the manner in which, because how do they do the public participation? I don't know whether you have done one. I participated. What they do, they tell you, they look at these common areas that we know from time immemorial. These Ofafa Jericho Hall, in those sides of, you see, they're looking at county government headquarters. They're looking at what. And sometimes they go to church very occasionally, and you find people going there. They have budgeted their own sodas and all that. They are there. They are sitting, listening. They are recording, transcripted, but they are not doing it to get what they need to get. In my opinion, they are doing it to meet that requirement that we went somewhere and people aired their views. You understand? So I think we blame the policymaker entirely. Now on this finance bill, the way it was, there's that urge on the side of the government. I've talked on the side of the Kenyans and myself, but on the side of the government, there's that urge probably to raise more taxes because, as I said, in our states or in our governments, we are still having a large fiscal deficit. Actually, this brings me to the EAC law. Do you know we have a protocol called Monetary Union Protocol, whereby we are supposed to have common currency the way we had it before? In this protocol, it prescribes what fiscal deficit, the ratio of fiscal deficit we should have, sorry, the ratio of public debt we should have to GDP. It prescribes the ratio, the inflation cap. It prescribes all this. But now we are not able to meet them because one is that we have so much financial outflows, illegal financial outflows through activities like corruption, investment, mismanagement. You see, mismanagement is not corruption. Someone is just put there because they don't have requisite skills. They're just doing things They don't even, follow procurement law. At the end of the day, you find that there's no value for money. Look at the parliament building, the one they launched the other day. From, was it 6 billion? And I don't know to what billions mismanagement. So government is trying to cure, which is very bad, to cure corruption, cure mismanagement, cure all those flaws with taxation. It is impossible. Yeah, so that is why now they become at loggerheads with Kenyans. And you see, Kenyans have spoken saying, no, I think we have enough. Because we have enough, they can still do those things. Kenya is still standing on its feet. We have not gone under economic recession. So if they can manage the little, and that's why you see there are so many people saying, can we even replicate the Finance Act of 2023, 2024? You understand? So that is the situation where we are.
Thank you so much, Wakili. Of course, I'm really grateful that you managed to come and talk to our viewers, fellow Kenyans. And maybe your final remarks, of course, you've also made us understand why the government has to tax Kenyans and the alternative ways, because you've talked of curing things like corruption, which if that one can be tamed, then we can be better off. I just want to get your final remarks. Maybe you can just generalize on the African integration, and maybe you can also finalize on the General Z. We are seeing them in Kenya. You saw what happened in the West African countries recently. You saw we had some coup, and if you look at the people who are leading this, most of them are young generations. So I don't know what that one means to the older generations, and maybe the message that they are sending to maybe people who still believe in taking some instructions from maybe the old guards who've been in this politics for long. Because right now, as it seems, the youths are taking over.
Yeah, absolutely. We can just combine the two, African integration, the quest for African integration, and the role of the youth. You are talking about West Africa. Senegal just gave us one of the youngest presidents. You see, and even if you look at Sierra Leone, even though the manner in which he took power, maybe others may say through coup and whatever, but looking at the age, we must say he's a young person. So integration of Africa requires young people more. Why do I say this? Because we are the people that have the information. We know what we want. Today, Africans are more empowered. Kenya, particularly, for those young people who come out of the street, I said it does not matter how they got the information. The bottom line is that they are informed. You understand? The bottom line that they are informed. So basically, young people have that, human capital dividend that they can use to actually create their own path. And for Africa to tap into the better future, we have some Africa economic blueprints, like the Africa we want, the Africa 2063. All these ones, if you look at the way they map the youth, they always put youth, but we don't see it in practical. I want to ask you a question. For example, if you take just take 10 African states that you know, and sample the ministers in charge of youth, and go to the African Charter that defines youth, because they define youth from 18 to 35. That's according to the African instrument. Then go to only 10 or 15, the one you know, and then ask yourself, the ministers that are leading those dockets, are they anywhere between 18 and 35? You will be shocked. So we need to lead from example. Even the things that belong to the youth no longer get them. In Kenya, we even revamped some of the like procurement act, whereby there are those procurement in the public sector that should belong to certain to a given percentage given to youth, given to persons with disability, and all those other special interest groups. If I am not wrong, today people register young people because they want them to appear in the certificate of registration so that they win those tenders. The guys who are performing are those same old guards. Now, the government do not come out, and as much as they create the Procurement Act to take care of the youth and all that, do they give us mechanism, or do they have the mechanism to ensure that the youth actually benefit from that? So I think it is absolutely right when young people now start, agitating. Let them ask questions. They can ask questions through any means that are provided for within the national laws. But of course, we must also make sure that as we do that, we don't have our young people going extra or indulging in other activities that will probably affect their well-being in terms of career or in terms of health or in terms of their safety. I think I can conclude that way. Thank you.
Thank you so much. Our viewers, that was Wakili Kennedy Abuya, who was trying to explain to us the African integration and, of course, the role of the regional courts, something that he really done well. I know next time he'll get time, he will come and we'll proceed with this kind of conversation, because as the world moves on, we are living in a global society whereby right now you interact and do business with people from different parts of the country, parts of the world. So we really need to understand some of these structures that are there, so that we can be able to update ourselves with the entire world, the entire Africa. And I know as we are pushing for the African agenda, we are soon having a dream of having one united Africa, the United States of Africa. So we need to update ourselves with such kind of things. So thank you so much, Wakili, and much appreciation from this end. And we welcome you back to Afrique 24-hour TV. So to our viewers, let us meet again next time. Thank you so much.